Let the record reflect that the defendant is present along with counsel for the defendant. Mr. Baez, I understand you have some matters you wanted to bring up.
Just, I guess, three points, three issues that I'd like to bring up. First off, for hopeful reconsideration of the court to yesterday's motion to exclude the Gentiva testimony. This morning, I in reviewing some of the stipulations that we had back in May of 2011, the 5th of May, there is an actual login profile information from Cindy Anthony, her employee profile that goes into her salary, the history, and some of the information relating to her employee status that the state and I were going to stipulate to. I think this is more evidence of the fact that the state was on notice of this information, and it wasn't until after the defense basically closed its case that they decided to bring forth this information. So I wanted to bring that to the court's attention and ask for a reconsideration on that specific ruling. The people from Gentiva were deposed by Ms. Sims yesterday. Unfortunately, Ms. Sims has a medical issue she's dealing with now and should be here shortly. But my understanding is after her deposition, she had requested to speak with two of the state's computer experts who yesterday, as we were leaving, I had a conversation with Mr. Burdick about new opinions that they are asking to render or are being asked to render in this case, which are not included in any reports. I asked if they had a report written on the new stuff. I was told no. I asked again this morning if they were going to issue a report. Again, the answer was no. They were also not made available yesterday afternoon when Ms. Sims asked for if they were there. I believe the two witnesses are the computer experts is Sandra Osborne, the lady with short hair, and Sergeant Stenger, the gentleman who wears black. And we would ask that the court hold the state to the same standard it held the defense with as it relates to Your Honor's order, that no trial by ambush, no opinions if they're not in a report or they're not deposed on. And it appears that that's what we might have a problem with all day, because I'm also aware that Dr. Bruce Goldberger is outside, and he also has a report in this case. And I don't know if he's going to testify anything outside of that. And then Dr. Warren, another expert, the anthropologist, who already testified and gave numerous opinions. And I do not know, my understanding is he's testified everything that he was going to talk about in his report. So if there's something new, we would ask that all of that be proffered and we see where exactly we stand with new opinions and no reports. And I think have lived up to our end and wanted to bring the court to make the court aware of those issues that we see right now.
Ms. Burdick?
As it relates to the members of the sheriff's office who were asked post testimony of Ms. Anthony to do keyword searches, that is the sum total of their testimony. There are things that Ms. Anthony said during her testimony that I asked them to check out. They did not issue any reports, and I advised Mr. Baez yesterday of what their findings were verbally. He can speak with them if he chooses to now. Ms. Sims at 5:15 yesterday mentioned that she wanted to talk to them. That was the first I had heard of a desire to redepose. Mr. Baez asked me if they would be testifying when we left, and I told him what their testimony would be, and it's exclusively in rebuttal to claims made by Mrs. Anthony last week.
What would they be testifying to?
That they did keyword searches based on information she provided in her testimony, and that there's no reference to those terms either in the unallocated, deleted Firefox history or on the entire hard drive. There's also an issue that arose as to whether or not Mrs. Anthony could engage in a remote login to her work computer, and I asked them to look for search terms that would indicate that she engaged in a remote login, and there are none. That was brought up yesterday.
Mr. Baez?
My understanding is that this task that they were asked to do would take approximately 2 days worth of work to search the unallocated space and the rest of the computer. We sure would have liked to have had notice of this testimony to have our expert be able to go in and do the same type of work. However, again, no report. We don't know exactly what they looked at, where they looked, how they did it, what software programs they used to do it, what hits they came up with that they discarded, what hits they didn't come up with. It's a whole complex process. It took them 2 days to do. And they could have placed us on notice that they were asking their experts to render new opinions, and they did not do that. They waited until our case was closed to tell us, this is what we're doing, this is who we're calling, and I mentioned to Mr. Burdick that it was in violation of your order yesterday. And I would think that if the state's on notice that we're going to challenge this, they may want to take steps to remedy it before we have to have this discussion with you this morning. And no such thing occurred. And now we are right about to close and submit this case to the jury. And these experts are now going to come in with new unverifiable opinions. And
How much time do you need, Mr. Baez?
I don't know until I see their opinions and what work they did. They haven't issued a report. And that's a requirement of this court to the state, that if the experts are going to issue opinions, they've got to write reports. No reports are written. So once I see that report, I can then show it immediately to an expert and see how long it would take for him to verify these results. And it's not just him, Judge. It appears to be now we're going to have Dr. Goldberger and Dr. Warren testify, and we may run into that issue again. Here was the big issue that I got into trouble with, and that was new opinions that might rebut something that the state says. And this court was firm and held its ground and laid out the way this needs to be done. And it's not being done by the state of Florida.
Is Dr. Goldberger going to render some type of expert opinion? And if he is he has he reduced that opinion in a report?
Yes, sir. He provided a report many years ago to defense counsel indicating that his evaluation of the cranial wash indicated nothing. He's going to testify that that nothing includes the absence of organic residue from brain decomposition, rebutting Dr. Spitz's claim made for the first time in this trial that he can, by looking at this residue, determine that it's organic material. He even claimed that he took a sample of it and gave it to defense counsel for testing. Dr. Goldberger will say that his wash doesn't reflect anything, including any organic material from brain decomposition. This is simply, as the court has said, a sub-opinion of the opinions already known and discussed by counsel. Would also state that Dr. Goldberger is listed as a defense witness. That's all he's going to say. And Dr. Warren is simply going to testify consistent with everything he's always said, which is that opening a skull is not protocol for an anthropological examination of a skeleton. And that is absolutely nothing new.
Number one, Dr. Warren is not a forensic pathologist. He's being called to rebut a forensic pathologist's testimony. I don't
What
think
is
that.
Dr. Warren?
He's a forensic anthropologist and the director of the Pound Human Identification Laboratory at the University of Florida.
Can direct all he likes. He's still not a forensic pathologist. And he's being called to rebut that of a forensic pathologist, which is certainly outside his field. And what Dr. Spitz testified to was
You want to take his deposition, Mr. Baez?
if necessary, I would ask that it be excluded. I don't see where this is rebuttal testimony. He can't rebut something Dr. Spitz says. Excuse me, I'm not finished.
Mr. Baez has the floor.
This is not submitted in his report. Dr. Spitz issued a report in this case and talked about that specific issue. Then Dr. Warren could have filed a supplemental report. And this was, I don't know how long ago, a year ago almost. And nothing of the kind ever occurred. So, again, this is stretching and creating new opinions for the issue of rebuttal. Furthermore, Dr. Goldberger did not testify or put down in his report about the interior of the skull and all that he testified to was the saline washes that he received and the testing of that. This is not a sub-opinion of that. Dr. Goldberger is a toxicologist. That's another person who cannot testify as to organic matter, what a forensic pathologist should be testifying to. Dr. Eichenboom had the strongest sanction put against him of exclusion of certain testimony for this very purpose, for creating new things that a report wasn't issued. And I would add, a report was done because I told him to do it that night, and he was deposed, and it was still excluded. I would ask the same sanction be issued to the state. The rules aren't different for each side. They apply to both. They were aware of this testimony by Dr. Spitz when he issued his report. They chose not to have their experts issue a report. And it should be to their disadvantage. They can't decide to ambush the defense after the defense has rested their case with new opinions.
Discussed in his report at length his participation in the examination of the skull. It cannot possibly be a surprise to Mr. Baez that this noted forensic anthropologist is going to testify that opening the skull is not required. That cannot possibly be a surprise to Mr. Baez. And Dr. Goldberger's finding, he is going to testify as to precisely the test Mr. Baez just discussed, the cranial wash and the examination of what was found in the cranial wash. It's nothing more than that. No other test, exactly what he talked about in his report, that there's nothing there.
But where's his report?
I'd have to go into my computer and find it. It was issued.
Mr. Baez, are you
Years ago.
saying that was not disclosed in his report?
The cranial wash was, but not an identification of what was found in that cranial wash. There was no examination. What he did is he did the cranial wash and he ran tests for chloroform, okay, and other volatile chemicals. He's never identified what the substance was in that cranial wash. And furthermore, he's not qualified to render an opinion on that. He's a toxicologist. He can only talk about the chemicals or whatever he ended up finding, but not identify it as being organic matter or not.
He's a what?
He's a toxicologist.
And the toxicologist can't say whether something is organic or non-organic.
If he can talk about the chemical composition based on the tests he ran. He can't look at something and identify it as organic matter, and he did not. And that's the important thing as it relates to him. Now, as to an anthropologist, he's going to try and testify now about something that he never inspected. The skull wasn't opened. He didn't inspect the skull when it was opened. So now, for some reason, the state wants to call him to talk about what a forensic pathologist does.
Well, isn't he going to testify according to what Mr. Ashton just said, that you don't necessarily have to open the skull?
To render an opinion that a forensic pathologist should? That's
an anthropologist, if he's duly qualified, more than likely can render that opinion. The bottom line, Mr. Baez, do you want to take their deposition? And this is what I will do. I give you the balance of this morning to take his deposition, but guess what? We will be here tomorrow till we finish this case, and we will be back here Sunday.
I would ask that the evidence be excluded as it was excluded for the defense.
And what evidence did I exclude? Did not you volunteer to exclude certain things when I said that the state would have an opportunity to take the deposition, that exclusion would be a harsh remedy?
The problem is, Judge, we can't reopen our case now. We're going to drag this on.
Mr. Baez, those are the alternatives. You are on one hand, you are saying that all of this is a big surprise to you, and you need time to talk to these witnesses.
Yes, sir. I will take their depositions.
And then on the other hand, I'm saying that I will let you take their depositions. But on the other hand, you will be here tomorrow to finish, and we will be back here Sunday. So it's not going to be one of those things where, because both sides had originally asked yesterday at the close of business, could they have off tomorrow to prepare for closings? So if both sides are if you are so troubled where you need additional time to take these depositions, then we will let you take the time, and we will work for the balance of the day to a reasonable hour of the night, and we will be back here tomorrow and back here Sunday and Monday and Tuesday if necessary and Wednesday. So you're saying that you're surprised that you need to take these depositions, and I'm going to let you take them.
Stay here and do the work as long as it takes, and however many days it takes, we will do it. That doesn't concern us in the least bit.
But I want to see those reports. I want to see the report, because you're saying that all this was not disclosed in the report. Now, I don't want to read a report and find out that it's there. And you're telling me that it's not in the report.
Judge, if it was there, Mr. Ashton would have jumped up and said it was.
Well,
we both read those reports. It's not there.
Well, all I want is a report. Pardon?
I do disagree.
Well,
The washes, as we both agree, are on there. But
then what's the problem?
him identifying them as organic matter. First of all, by the way, he's here right now.
I mean, either the man is qualified or he's not qualified to do that.
One thing that maybe counsel is misunderstanding me on. He's going to say that it's not organic matter. He's going to say that it's not there. Not that it is, but that it's not there, because counsel, I think, may have misunderstood me. He's going to say that it not only is it not chloroform, not only is it not drugs of abuse, it's not organic matter as you would see from decomposition. So it's a not that it is.
So how much time?
Those findings are not in his report.
Well, y'all can go back and forth. Just get me a copy of the report. How long are you going to need to talk to these people?
I don't know what new opinions they have, so I will start right away, and then we will take it from there.
I just told counsel what the new opinions are, and that is it. So the deposition should be fairly brief on those issues.
So I guess the state is admitting there are new opinions now.
No, I am not. But if we can stop this and maybe just get to some actual work, Judge, I'm ready to go.
All right, we will be in recess subject to call. Remember, y'all can take as much time as you want, but you got jurors back there, and they have been sequestered, and there are real problems and there are imaginary problems, and I hope this is a real problem and not an imaginary problem, because I will give you all the time that you need, but if I find out that this is an imaginary problem, because these folks are ready to return to their homes. Okay, we'll be in recess subject to call. Tell the jury that we be in recess indefinitely. Another thing y'all need to craft is y'all never did agree on a statement dealing with Dr. Rodriguez.
I think that if I recall correctly, you heard objections from the state, and then I thought maybe the court was going to draft something, but I'm not sure quite where we left it. I know that we argued about the language that the defense requested, and I'd objected to it being outside of the facts before the jury.
Well, the state can give me some language they would like to see. The defense can resubmit their language. But be prepared to be here late this evening. Okay?
Do deposition rooms at the same time so we can get everybody.
I don't care what y'all do, folks. All right.